Welcome to Fraud Talk, the ACFE's monthly podcast. I'm Cora Bullock, Assistant Editor of Fraud Magazine, and this month I interviewed Frank Wisehart, CFE and Director of Business Advisory Services at Schneider Downs and Company's Columbus, Ohio office. Prior to joining Schneider Downs, Frank was president of a certified public accounting firm specializing in business valuations, litigation support, and forensic accounting. Today, Frank discusses rookie and not-so-rookie mistakes expert witnesses make when writing reports to be submitted to court. So Frank, how did you get into the accounting side of legal work?
My father was an attorney. My grandfather was an attorney. I was named after my grandfather. You know, they had a law practice. I was destined to be another attorney, but instead I found a lot of interest in the accounting side of legal work. So it's kind of a interesting thing. I do enjoy it. It's one of the few places in, I think, accounting where it can kind of be a competitive environment. And as a person that played a lot of sports and did those things growing up, it's a fun place to try to put your case forward and put the facts forward and do a good job for your client and win the issue of the day. I mean, it's one of the neat areas in accounting that's unlike others in that you can actually make a difference, have more preparations, a little more free in terms of how you prepare, what you need to do. And it does come down to your individual ability to present. Part of the things that make people good forensic accountants are the ability to tell the story very simply about what happened. And if you can be a good storyteller or you are a good storyteller, then this would be a really good field for you to consider.
That's great. So tell me, what are some common rookie mistakes expert witnesses make when writing their report?
Simple things like fail to check your grammar, fail to be good at English, fail to have or include copy and paste errors. You know, you're taking something from an old report and you copy it into the new report, and then you don't do a good job of looking through it. And those are what I would characterize as death by 1,000 paper cuts. The point is that's going to be made against you is, you know, if you're sloppy in this area, if you're sloppy in that area, if you're sloppy in 4, 5, or 6 different areas, you know, when you start to add those up, the person that's looking at you and judging your credibility is going to say, well, wait a minute, you know, if they made mistakes on the simple stuff, then, you know, have they made mistakes in the big stuff as well? And that little bit of doubt that can creep in can be, you know, a real problem for credibility. And once you lose your credibility, you've really lost the case.
Why is a CV important, and what are common errors people make with one?
The first problem is people don't even know what CV really means. It's called a curriculum vitae, which is similar to your resume, but it shouldn't be used as a marketing brochure or a marketing piece or anything like that. It's really kind of to establish why it is you're an expert, or why should we listen to you. You know, what is it about you that distinguishes you as a person as having some additional knowledge or training or expertise or something along the lines that allows us to think of you as someone who is an expert and has something to offer in a particular subject matter that the regular person doesn't necessarily have on their own. And so, you know, that's going to be communicating what your background is, your education, your training. And specifically, you know, when it relates to fraud, there are guidelines that you have to follow as to what is in your CV. And particularly younger people into the profession don't really grasp exactly how critical those things are. And so what happens is if you're in a federal case, for example, and you put together this great report, let's say, and you got all this stuff, and you don't fill out the check boxes, or you don't put the stuff together that you're supposed to, and I don't mean check boxes literally. For example, you don't have the elements that's required under this statute called 26 Federal Rules of Civil Procedure 26A2B. That articulates what your CV is supposed to have. And so you're supposed to have, you know, your background, your education, you know, what all licenses do you hold, what are your certificates, you know, when did you receive them, the last 4 years of court cases that you've been involved in, the last 10 years of presentations or articles that you've published or authored. And then in addition to that, what your level of compensation is for this particular case. You have to have all that stuff in your CV in order to have a federally admissible report in federal court. Now, state courts are different in that you don't have to have all that stuff, but it's generally a general requirement that people who are experts and testify and do stuff in fraud examination generally have a standby CV ready to go at all times. And the reason for that is because in this field, lots of stuff happens at the last minute. For example, attorneys wait until the last minute to hire you, and so when they wait until the last minute to hire you, and this happens to me all the time, it could be I get a call Friday morning and they'll need my CV by that afternoon in order to submit it to the court to say who they have identified as their expert on a particular case or an issue. So those of us that have been around for a while always have, like we're Minutemen, and we don't have a revolutionary rifle to grab. We have our CV to grab in order to submit for the cause.
What should your cover letter have?
People write and do great reports, and then they'll put something silly. And the point is the cover letter should just be very generic and dry. Here's the attached report. Thank you. Sincerely in your name. It isn't a time to start putting marketing in or other types of things, because when the other side reads that and reads that critically, they can be looking for some kind of a favored relationship with a certain prosecutor or with a certain attorney that you may be working for. So the key is just really to keep that very, very bare bones and generic when writing a good report.
What is some more advice for expert witnesses writing their report?
Take out all the superlative language, and nothing is awesome or great or cutting edge. We just try to state the facts, and then every paragraph we look at it and say, okay, if we were talking about facts or opinions or anything like that, whatever that is, we try to reference that back to the documents that support every single paragraph and every single sentence and every single paragraph where there's an assertion, so that we can know and point to what those documents are and describe them. And I think that's fairly critically important. So in essence, we prepare all of our reports from a defensive perspective rather than an offensive perspective. So we're not trying to go out and attack and make leaps into areas that we don't necessarily have all the information about. Rather, we're trying to really well defend those areas where we think we've got some really solid evidence and build a report based on that.
What are the areas in your report that are most vulnerable to opposing counsel?
Any good defense expert will tell you, anything that's attacked in your report, the first thing they're going to attack is the evidence that you have. If you think about it, like when people get caught, and if you look at it from the defense perspective, if they can keep the evidence out, then the whole case and the whole problem goes away. So you hear about these cases in the news where the video evidence is thrown out, or the videos that they took were not admissible into court, and then the case crumbles. Well, it's the same thing really on a lesser scale perhaps in fraud examination, and that is if you don't really have good evidence and you don't present it, and then secondarily if you don't present it in a compelling fashion, then your case starts to crumble and then starts to go away, and it starts to work in the favor of the defense. And the second area is going to be, what standards are you applying? The thing that you have to do and the thing that you have to understand is, what is the standard that you're applying to say that someone did or didn't do, or stole things or ripped things off or whatever? I mean, what is the standard for anything that you do, for anything that you're trying to say in an expert type of situation? What is the standard that you're applying? Is it legal standards? Is it accounting standards? Is it fraudulent standards? Is it what is that thing that you're using to measure against that you're saying that this person violated or did wrong or abused their position or their position of influence or that kind of thing? I mean, those are kind of the two critical areas that an expert or a fraud examiner needs to understand. the people that read your report aren't, always necessarily the people that you think will read your report. So, for example, you expect that the judge and the jury would be the people that would be most interested in your report and most interested in reading and dissecting every detail. But, in actuality, when you submit a fraud case or something like that, the person that's going to really critically read your report is going to be defense counsel.
Tell us about gathering facts for your report.
If I said to you, you have a limitless number of documents available to you, what is it that you want? And this is where I think people, make a mistake. They don't ask for the right information, and they get this set of information that's handed to them, and it's cherry-picked in order to lean your opinion in one particular way. I mean, you've heard that Paul Harvey's, and now the rest of the story kind of thing, where it completely changes your mind once you get the additional facts. So I've had those types of situations happen to me where we're sitting in deposition, and the attorney says to me, well, Mr. Wisehart, did you have this piece of information? And I said, no, and I looked at my counsel, retaining counsel, who didn't provide me with that. He said, well, would you like to have that? And of course, I said yes, and we go to the next item. Would you like to have this particular item? Was this provided to you? Yes, I would like to have it. I answered, and no, I didn't have it before. And I start to realize that all this stuff that was withheld from me directly affected my report. And, my report of damages that was something like $850-some thousand in damages is now whittled down to $100-some thousand worth of damages. But through the whittling, the credibility has been lost.
Was that just horrifying for you as this unfolded?
Well, heck yes, it was horrifying. And what happens is whenever an attorney says this to you, something really bad is about to happen. And that's when they hand you some pieces of information that you haven't seen before. And he utters these great words. He says, go ahead and take a look at this and take your time. Now, anytime opposing counsel hands you something and says, take your time, then you know that something really bad is about to happen. And that's, of course, what happened in this particular case. I looked at the information. We took a recess. I asked for a recess of like 30 days. Of course, that wasn't going to happen. So we got 15 minutes, came back, looked at it, and you have to just take it. And you say, yes, you're right. Yes, I'll change my report. And what happened is he says, well, would you mark through that particular line item on your report that's incorrect? And I said, yes. And, you're taught to just answer the questions straight up. Just don't make any excuses. Just say yes if you made a mistake. And so we did that. And then he says, would you mind using my pen to make those corrections? And I said, no, I wouldn't mind. And so he reaches into his pocket and he pulls out this like Triton. Okay, it's not a pen. It's like a three-pronged Triton. It's bright red with a very sharp tip at the end. And so I lined through that particular line item. And I'm thinking, okay, finally we're done with this one. And he says, well, now, would you mind, Mr. Wisehart, initialing each and every place that you marked through so that we know that you made all those corrections and I didn't or someone else didn't? And so, this went on for 45 or 50 minutes. My report had so much red ink, I thought, if we shook it, it would bleed. It's a frightening experience. You hate to go through that. But that's one of the aspects about this type of work is many times you have to learn or good experiences predicated upon having bad experiences. And so you have to take it and learn from it and know what you need to know. Now the point that I'm trying to make in this is had I known or had I asked for the information that I wanted and not just simply accepted the stuff that was given to me, I might have had a better chance of heading this thing off. Where people make mistakes are they have good pieces of information, like the example where we had some solid damages for $100-and-some thousand, but they tried to cram in $800,000 worth of damages, and then later the thought process, just to complete that story, thought process on that afterwards, when I asked the attorney what the heck that was all about, he said, well, I thought it would settle. We thought we'd get some money and settle, and that's a really losing strategy. And it's the same thing with your report. You need to be able to state what you can state and stick to the facts and stick to the stuff that you can defend. And if there are areas where you have to make an aggressive leap of faith, as a fraud examiner, you need to let the attorney know that that's his job to do that, not yours. An attorney is an advocate, and you're really there to represent the truth or the facts or the court. And so you need to stick to that role.
And what should experts do once they write their report?
So when you get to the end and you write your report, generally what I like to do is I'll give whoever it is I'm delivering the report, I'll give them a date into the future that I'm going to deliver the report, and then I'll give myself an internal date to complete it. And normally I like to have a week in between those dates whenever that's possible. And the reason is I like to get my report done and then go back a few days later and look at it. I mean, how many times do we write stuff, right? And we go back and we look at it, a month later or a few days later or whatever, and we can't believe we actually wrote that, right? So you give your mind the ability to pause and regroup and rethink about it, the data itself, and that's a great kind of proof reading or editing type of thing for you to do. And then the second thing is copy the report, each paragraph, into Excel. And then to the right of it, if you've ever seen like an audit program or how they do those things, to the right they'll have the places where you identify the work papers or the things that you have that support the assertions to the left in like an audit program. And so we'll do it kind of the same way with the report, and we'll go through and we'll document where all those things are in each paragraph, that all the data that support the conclusion that we're reaching. And so that's a great thing to have. It's a great way to go. It's a great way to feel confident that you have actually beaten up your own report to make sure that you have the data that you need in order to back up your assertions that you have within the report and its body and its conclusion, etc.
What is some more advice for expert witnesses writing their report?
I was talking with one of the great judges here in Ohio, Judge Sheward, and he was telling me this story about how people don't know what their standards are. And he was talking about this case where a guy was testifying in a matter where there were millions and millions of dollars at stake. This guy had sold his company to the successor, and in the agreement with the successor, he was required to deliver his best efforts in order to transition the business from him to the successor organization. And so, this guy received a big payment in the tens of millions of dollars for his company. He went off and traveled around the world and played golf and did all these other things and didn't do what he was being paid to do, or which he was contractually obligated to do, which was devote his best efforts to helping in the transition of the business. And so this attorney for the plaintiff, who then sued for lost business value, brought in an expert, a CPA, who was testifying about what best efforts means. And he was talking about how many hours a week someone should work and how many hours, someone should devote and what that would look like and the relationships and so on. And none of this stuff was really valid. He said had the other side brought up some legitimate points about what is the standard for giving your best efforts, that he would have balanced that particular witness and what's the standard for using your best efforts. Well, there really isn't one, and since there isn't one, a person can't testify or bring someone in as an expert about that. In other words, that's something that the jury or the judge could pick up on their own. They don't need an expert to tell them what that is. The point that Judge Sheward was making in all this is know what the standard is that's been violated and be able to recite it. And once you really understand those issues, then your report generally tends to have a great deal more credibility in how it's presented and how it's perceived by its audience.
Today, Frank detailed many mistakes to avoid. 1. Don't make basic mistakes. Spell check and don't use your cover letter as a marketing tool. 2. Have good evidence and present it in a clear, compelling fashion. 3. Know what standards you need to apply to show what someone did and did not do, such as legal standards or accounting standards. 4. Your CV establishes yourself as an expert. Have it updated and ready at any time. Follow the guidelines of the statute Federal Rules of Civil Procedure 26A2B. 5. Know what you need to know. Don't simply take the information provided by the person who hired you, as they may have cherry-picked it to present the best possible case for their client. Get all the documents and information you need to maintain your professional expertise. Thank you for listening to Fraud Talk. We hope you'll join us next month.